You're listening to Audiology. Support our work on Patreon and be sure to submit your request for topics in the comments below. Originalism is the idea that the interpretation of legal texts, including the Constitution, should be grounded in the original understanding of those texts at the time they were adopted. Its supporters are against judicial activism and other interpretations that view the Constitution as a living document that evolves over time. Instead, originalists believe that any changes to laws should happen democratically through legislative action or constitutional amendments. This approach to legal interpretation really began to shape American legal thought, practice, and education in the 1980s. However, it's important to note that originalism hasn't become widely accepted in many democracies around the world. Its main stronghold is in the United States and, to a somewhat lesser degree, in Australia. Conversely, there are those who believe in the concept of a living constitution, which advocates for a constitution that adapts and interprets law based on contemporary understandings. Originalism itself isn't just one single idea, but rather encompasses several related theories about how to interpret the Constitution. These theories can focus on the intent of those who wrote or ratified the document, the original meaning of the text, a combination of both, or solely the original meaning without considering its expected application at time. It's also important to distinguish originalism from strict constructionism, as they are not the same thing, even though they might sound similar. Supporters of originalism believe that from the founding of America up until the New Deal era, interpreting laws through originalism was the predominant method. Subsequently, other theories began to gain popularity. In the modern era, Robert Bork, in 1971, introduced a new perspective on originalism. In an article for the Yale Law Journal, he discussed how judges might impose their own values in the absence of clear constitutional directives. Bork advocated for a method where judges should adhere strictly to the values and rules explicitly outlined in the constitutional text or understood from the framers' historical intentions. He argued that this approach would prevent the Supreme Court from making subjective value judgments. Following this, Raoul Berger, in his book Government by Judiciary in 1977, criticized the decisions of the Warren and Burger courts for deviating from the Constitution's original meaning. In 1985, Edwin Meese, the Attorney General under Ronald Reagan, advocated for originalism in a speech to the American Bar Association, calling for principles of government to be interpreted without ideological bias. However, Justice William Brennan challenged this view, stating that it was impossible to precisely determine the Founding Fathers' original intent and that the Constitution must be interpreted within the context of contemporary society. The term originalism was coined by Paul Brest in 1980. Throughout the 80s and particularly in the 90s, with the appointment of conservative judges to the Supreme Court, originalism saw significant growth in popularity within the conservative legal community, partly supported by the Department of Justice under Reagan. Justice Scalia emerged as one of the Supreme Court's early adherents to originalist views, later joined by Justices Thomas and Alito. The judges appointed by President Trump are also predominantly viewed as originalists. As of May 2024, it is reported that conservative justices are exploring new methodologies in interpreting originalism. Originalism has significantly influenced American law, most notably in interpretations of the Seventh and Second Amendments in key legal cases. Originalism comes in different flavors, but one key version focuses on the Constitution's original meaning. Justice Scalia, a major figure in originalism, saw himself as someone who looked at the original meaning rather than the framers' intent. He explained his viewpoint like this: originalism treats the Constitution much like any law, where the words are given the meaning they were understood to have when they were first written. While some people might talk about the original intent, you won't hear me using that phrase. That's because I'm a textualist first, meaning I focus on the actual words, not what the framers might have been thinking privately when they wrote them. For me, it's all about the words as they were presented to the people of the United States and how those words would have been understood at that time. Neil Gorsuch, in 2019, made a point about originalism, a legal principle. He stated that originalism helps keep judges impartial. According to Gorsuch, this means that judges should ignore their own opinions on policy when they make decisions. He believes that by doing this, judges support democracy because they are not trying to shape policy through their rulings, which is something originalists argue against. Gorsuch also mentioned that when you really look at what the Constitution originally meant, decisions from the past like Dred Scott and Korematsu just cannot be justified. It's interesting to note that Sam Ervin, a known segregationist back in the 1960s, was an early supporter of originalism. He used it in his arguments against civil rights laws. Calvin Turbeek suggests that the popularity of originalism today is the result of a conservative backlash against the Supreme Court's Brown versus Board of Education decision and some civil rights laws. Supreme Court Justice Elena Kagan points out that the Constitution intentionally includes broad and vague terms designed to let future generations interpret its meaning as society evolves. Michael Waldman highlights that originalism is a relatively new idea, not one held by the Founding Fathers. He criticizes conservatives for adopting originalism because it suits their views, rather than being inherently originalist. A study published in the Columbia Law Review in 2021 found that the Founding Fathers didn't embed a non-delegation doctrine in the Constitution and were okay with delegations in legal theory, which contradicts some originalist claims. Ruth Marcus questions why we should stick strictly to the Constitution's original meanings in a time drastically different from when the United States was agrarian and when Black people and women were severely oppressed. She believes the Constitution was meant to be flexible, adapting to unforeseen future circumstances. Jamal Green notes that originalism isn't popular outside the United States, where countries typically prefer approaches such as minimalism or textualism to combat judicial activism. Justice William J. Brennan Jr. called originalism arrogance cloaked as humility in a 1985 speech, emphasizing the folly of claiming to understand the framers' intentions fully and critiquing the political motives behind such claims. Many people who follow the originalist interpretation of the U.S. Constitution believe that international law shouldn't influence American law, except for British law that predates 1791. Justice Scalia, reflecting on Chief Justice John Marshall's thoughts from the landmark case Marbury v. Madison, emphasized, "We must never forget that it is a constitution for the United States of America that we are expounding. Where there's no clear agreement among our own citizens, we can't apply the opinions of other countries, no matter how wise they may seem to the justices, to Americans through the Constitution." Antonin Scalia made a clear distinction between two ideas by explaining how a strict constructionist might not accept that saying he uses a cane is the same as saying he walks with a cane, because technically those are not the exact same expressions. Scalia emphasized that he did not agree with strict constructionism, stating, "I am not a strict constructionist, and no one should be." He went even further to criticize strict constructionism as a lesser form of textualism that tarnishes the reputation of the entire philosophical approach. Legal expert Randy Barnett offers that originalism should be seen as a method of interpretation, suggesting that the concept of constructionism only really comes into play when it is challenging to determine the original intent behind a text. Declarationism is a legal theory that treats the United States Declaration of Independence as an essential part of case law, right alongside the United States Constitution. This approach sees the Declaration as a document based on natural law, meaning it believes that natural law should play a significant role in American legal practices. Key supporters of this viewpoint include Harry Vide Jaffa and Clarence Thomas. Thanks for watching. Share your thoughts in the comments and subscribe for more content.